it seemed to me that governments until recently accepted certain restrictions on their own power because they knew that sometime they were likely to be replaced by a government of a different complexion. And if they introduced anything which tended towards absolutism, then that absolutism would be taken up by people they might find less appealing. And I think that tension, the feeling that you were in power for a certain amount of time and then someone else would probably take over, because that has been the pattern over the last century or so, restrained governments from wanting to go too far. Whereas there's a distinct sense nowadays, it seems to me, that governments are really living for the short term. They're interested in tomorrow's headlines, and they don't seem to worry about setting precedents. And so all the conventions which, as Mr. Straw recently said, existed in hearts and minds and habits, have been thrown away. And you can only do that once you've thrown away all those conventions and practices which have developed over a long time and it's sort of worked by general agreement. Then you're in difficulties, because there isn't then anything which holds the government in check except Parliament, and if Parliament isn't doing it, we've only got the judges left. And the point of a written constitution isn't so much to put principles into words, it's about giving power to judges. Well, it seems to me the sole purpose of a written constitution is to give power to judges. That's not perhaps the way the present government sees it, because they don't want to give power to judges. They would like to use it as a declaration of aspirations and so on, which can't be legally enforced. But a written constitution, in the proper sense of the word, is something which binds government, and the only way in which you can bind government is to have a judiciary capable of enforcing a constitution. I often tease my American friends by saying you don't have a written constitution at all. Your constitution is what the Supreme Court says that the words mean, which is often completely different from what the words actually say. And so I think one can lay too much stress on the wording. But the question is whether you're going to give the judges power, but at least if there's a written document within which they've got to operate, that I think gives them rather less absolute power than if you just let them determine principles as they go along.
In this context, when you're talking about a written constitution, are you meaning merely a codification of our existing constitutional principles, as it were, or our existing constitution, or do you mean an entrenched constitution which is not only written down but also cannot be changed unless some specific special procedure is gone through?
Oh, it would have to be entrenched. There's no point having a constitution with judicial review by the judges if Parliament can just change it again every time there's an adverse judicial decision. But of course there are different sorts of constitutions and different aspects to constitutions. There's the Bill of Rights aspect, the human rights aspect, which we've already to some extent got, though without judicial review in the American sense, but we do have judicial pronouncements on the Human Rights Act. And then there's the structure of government sort of constitution, which we don't have. And they can be treated separately.